Section 25 capital A of the Drug Misuse and Trafficking Act 1985 makes it an offence to supply a drug on an ongoing basis. It's often called ongoing supply. Ongoing supply is supplying a prohibited drug other than cannabis on 3 or more occasions over a 30-day period for financial or material benefit. The maximum penalty is 20 years imprisonment and or a $385,000 fine. It's what's called a strictly indictable offence, which means it cannot be finalised in the local court. It must be finalised in the district or Supreme Court. In order to prove ongoing supply, the prosecution must establish beyond reasonable doubt that 1. You supplied any prohibited drug other than cannabis on 3 or more occasions over 30 days, and the drug that you supplied on each occasion doesn't have to be the same. You don't have to supply 3 times speed or 3 times ecstasy. You can be guilty if you supplied on one occasion, for example, speed, and on the other ecstasy, and on the other heroin. It's just 3 or more occasions that you supplied a prohibited drug other than cannabis over a 30-day period. That's the first thing. The second thing the prosecution must must prove beyond reasonable doubt, is that you received a financial or material benefit for yourself. Now, what's not ongoing supply? It's not ongoing supply if you sell for someone else and get no money or material benefit for selling. For example, if you sold for an employer and you did this out of a favour and you did not expect any material benefit or reward. Same if you did it for a friend. So that is not ongoing supply. It's not ongoing supply if you give it to friends for free over 3 or more occasions over a 30-day period. So there has to be some sort of material benefit or reward. It is ongoing supply if you sell for someone else and get money for it, or drugs for it, or other gifts for it, even if it's only a small amount of money or small gifts. It also is ongoing supply if you sell for your boss in the expectation that you're going to get a promotion or some other type of non-monetary reward. Now, if you are charged with ongoing supply, it's a good idea to get an experienced criminal lawyer to try and at least get that dropped from ongoing supply to drug supply simpliciter, so just drug supply. The reason is ongoing drug supply is treated very seriously by the courts. In fact, the law says that a person must go to jail for ongoing drug supply if they're found guilty or they plead guilty, unless there are exceptional circumstances. Now, in terms of supply, if you can get it reduced just down to supply, depending on the amount that is supplied, the case may be able to stay in the local court, and that attracts much lower sentences. The maximum penalty for supply in the local court is 2 years, which is of course far less than the 20 years for ongoing drug supply. So if you have a serious drug case such as ongoing drug supply, you should see a lawyer who's experienced in serious drug cases, has a good track record. Where the evidence is strong, they can again get it reduced to a less serious charge. Where the evidence isn't so strong, they can fight to win the case in court and keep you out of prison and keep you conviction free.